Do you know what triggers an investigation at work or what happens if you become the subject of one? What about the rights you're entitled to receive when you file a complaint? And what actions employers are prohibited from taking before, during, and after an investigation? Well, today we're talking about all of this. Plus, stick around until the end because I'm going to share some tried and true tips with you about filing a complaint. Hi, I'm Harlow Reed, creator of the HR Insider. Today we are talking about workplace investigations and how they tie to litigation or claims filed with the EEOC or Equal Employment Opportunity Commission. I get questions about this topic all of the time. People are so curious because understanding this process and how investigations work can be a matter of success or failure in obtaining the best possible outcome for you. So let's talk about it. The content shared on this channel is for informational purposes only and is not a substitute for professional legal advice. Always consult a qualified attorney or HR professional for specific guidance tailored to your needs. Don't forget to like and subscribe. Something has to create the need for HR to conduct an investigation. We're going to walk through some of those activities that are most commonly identified as generating or triggering an investigation. The first one is an employee complaint. Protections, federal or state protections linked to it, such as allegations of harassment, discrimination, or retaliation. Those things are going to be automatic reasons to conduct an investigation. And I want to distinguish employee that goes to HR, complains about a coworker, or complains about their boss, or complains about general personality conflict, those things are not going to require an investigation unless it rises to the level of harassment or some other federal protection. Policy violation, where someone is stealing, clocked in when they're not really working. Activity is a whistleblower report, someone who raises a concern about unethical things happening in the workplace, illegal activity in the workplace. Think about fraud, someone who is misappropriating funds, or safety violations, like we had a lot of those during COVID, where people were filing complaints with OSHA and with HR because they felt like their workplace was not safe. So, any kind of whistleblower reports will require an investigation. Managers can also observe their employees doing to them, let's say, drugs and alcohol is a common one, or employees that are invading other people's space, making other people feel uncomfortable. There's also performance deficiencies. Those are the types of things that supervisors can bring to HR that could trigger an investigation. HR also observes things. They can conduct their own investigation. And then, of course, you can have federal and state authorities that make HR or your employer aware of things that have happened with you. Let's say if there's an arrest, and also a current investigation that provides new information could also trigger a investigation. And be work events, things like reduction in force, layoffs, restructures that all have to be done in accordance with federal and state laws. Those types of things can also trigger an investigation if someone complains about the way that they were handled. The next step is to conduct interviews. The first interview that is going to take place, person who made the complaint is always the first person that should be interviewed. Next, they're going to interview anyone who is accused, people that are being complained about. They're going to interview them next, and any witnesses. Now, during these interviews, there are a couple of things that are going to happen. Should always be standard operating procedure. Your person you're interviewing with needs to let you know who they are, why you're there. They have to let the person know that they're free to leave at any time, even though there are usually policies about participating in investigations and being transparent. If an employee feels uncomfortable, they have the right to leave. They're going to document all the information that they gather from all the witnesses, all of um, the person who's accused, the person who's making the complaint. They're going to get anything relevant to that complaint to review it to determine what is the best outcome for the complaint that has been raised. Now, if you are the person who is accused, HR should notify you of exactly what you are being accused of doing. They should have the opportunity to explain and defend exactly the allegations that are being made against you. You are entitled to that, and you have a right to state what your response is to any allegations that are made against you. Now, when you're the person who is filing the complaint, you have the right to be heard and to have all of your concerns addressed, not just the primary one, but to have all of them related to your claim addressed. You also have the right to an investigation that is fair and objective and does not have bias. And it's very important that your employer demonstrate that to you, because again, that is your right. Employers cannot retaliate against anyone during an investigation, after an investigation, and even someone who's been identified as a party to an investigation but haven't been spoken with yet. um, HR cannot, the law is very clear on the fact that they are prohibited from taking action against people who are involved in an investigation. This is not just the person who's making the claim, but also the person who is accused. The other right that people have who participate in an investigation is for witnesses. Witnesses cannot be retaliated against. They cannot be held accountable because they shared truthful information and it ended up hurting someone who is a key player to an organization. What an employer is obligated to do, and a fair and unbiased investigation, not retaliating against people who participate in an investigation, and also having a thorough investigation done are just some of those key um, obligations that your employer has. So, what's the link between EEOC claims, litigation, and investigations? Well, documentation is a key evidence in these types of claims. And what happens is if an investigation is conducted and it is not thorough, or there are gaps in the investigation, meaning people who needed to be interviewed were not, or the complainant's concerns were not fully addressed, these types of things can hurt the employer because the employer can assert a good faith defense in court. And a good faith defense shows that they acted promptly and that they took the complaint seriously and that they were fair in conducting their investigation. And it is a very strong defense in court. But if that is not demonstrated in the documentation, then it can hurt the employer and it can establish a bias that makes the employer look negligent in the complaint and how it was handled when it was brought to their attention. So, if you are an employee and you would like to file a complaint, you need to include specific details about what has happened. Be specific as possible. Include dates, times, witnesses, what happened, how you perceived it, and how it made you feel. Those things are all very relevant to a claim because it establishes the legitimacy of what you have experienced. If you feel like the investigation was unfair, or if you feel like you are being retaliated against after you filed a complaint, remember you can report it to the EEOC. And this is something that you should do because it does have an impact on the workplace, on how the way that investigations are handled in the future with your by your employer, and also it has an impact on you and how this is resolved for you ultimately, because you have suffered and you are entitled to compensation for what you have endured. Finally, if you do not get a letter of conclusion or some kind of documentation to demonstrate what the outcome of the investigation was, you should ask for that. When you get it, it should include any policy violations that have occurred, or if there have been no policy violations that have occurred, then you should have that as well. You can use that information to help you determine if, in fact, there was a thorough investigation done. What I mean by that is if you provide your employer with clear and definitive proof that more likely than not, a violation of policy has occurred, and you get something back that says a violation of policy that has not occurred, it's not likely that a thorough investigation was done. And that's when you do need to go and consult with an attorney and file an EEOC claim. HR investigations can feel intimidating, but if you can understand the basics, it really helps to give you insight and feel empowered and confident if you are confronted with a need for an investigation or if you are a party to an investigation. I hope you found this video helpful. Give it a thumbs up and subscribe for more insights on workplace challenges. If you have a question about an investigation or workplace rights, drop it in the comments and I'll cover it in a future video and I'll try my best to answer. Thank you for joining me on the HR Insider, and I'll see you next time.